This podcast may contain disturbing content for some listeners. It's intended for mature audiences. Listener discretion is advised. This is True Crime XS.
I've got some interesting news, and then we'll get into today's case. So I don't have a lot of true crime news like right this second. I mean, I have a lot of true crime news, but I don't have anything prepared to talk about. What I did have is I have started doing public records requests in a couple of different places because I think we're going to have a couple of episodes coming up on Israel Keys. Although I will have to preface everything I do in this next round, although you've been looking at it, people haven't. These are all theories I have, theories I have that I can't back up 100% with facts that sort of fit ideas I've had along the way. You know, he's weird how he doesn't really make for a whole new season of his story, but like I find myself every once in a while, and I think I told you this morning, I had like 500 tabs open on all these different devices, and I'm just realizing that that obsession does not die for me.
It never goes away. Like, I constantly reevaluate things against like all the research I did on that case. I had taken the timeline off of my cloud, so it wouldn't be taking up so much room on my phone, and that's the timeline of what Keys was doing like throughout this span of time. And I had to put it back on because I wanted to reference it because I can quickly look up. It's a spreadsheet that it's based off of like the FBI file, but it's my own because I based on additional details that were, given in other places for whatever reason. And I'm having a lot of trouble remembering why I did certain things now that we're kind of going through a new batch,
Yeah.
I have certain things that I had decided on and I wrote it in my notes, and then when you come up with something, I'm like, wait, why did I say this or that or the other? But anyway, so yeah, you got me to download it back into the cloud so I could access it. I had taken it off because I was like, man, I don't want to think about this guy anymore. But it doesn't matter whether you're feeding it to my brain or not. On one of the recent episodes, we talked about how I had picked out a body. It just happened to be like the most recently entered unidentified body. And I found the identity of that body. And then it, through, sort of a blunder of everything happening in life, it kind of got pushed to the side. But I spend a lot of my time going through NamUs, looking at unidentified bodies and missing people. And I realized the very first thing I do is compare the situation to Keys's timeline.
I have found more and more that I do that. And, other people at varying levels of investigation put together resources on the internet. Like you sent me something this last couple of weeks that had some of the names of my most recent Keys adventure on it. It was like somebody had put together a Google map and they had included as many of the missing, unsolved, and unidentified remains cases
geographically
with upstate New York.
Right.
And that was pretty fascinating because, New York has always been a weird place for me for two reasons. One is because you have this major, the biggest metropolitan area, which makes it so difficult to search from the perspective of like archival news, which is one of my specialties, is being able to go through and find odd search terms in old newspapers of things that people forgot.
That's interesting. I don't ever think of anything about Keys in terms of like New York City. That's
Well,
interesting.
I don't think of him in terms of New
But
York
it comes
City,
up,
but
right?
in trying to search, like I
Because if you put
do,
New York in, it's everything, right?
yeah, it's everything in New York. And the same is true with Montreal. I've tried to like hunt things he might have done in Montreal, but I can't figure out the time period. I've got a brand new theory related to two of his places that he called his stomping grounds. And then like I went back and recently
And
listened to his interviews where he was talking about his stomping ground being like upstate New York and New Hampshire and Vermont and Maine. And I'm like, what does he mean?
what was the other place?
What do you mean the other place?
You said a couple of his stomping grounds. Was it just that area up there?
That's what he said. But I have places we've put him before. Like we know he was in Texas. That's a
Right.
stomping ground for me. Is Texas?
Well, I feel like I know he says that was my stomping ground, and it is in reference to, the northeastern United States, New York, and the trail you take to get from New York to Maine, right? Between those states, like you said, New Hampshire and Vermont. And that has bothered me so much because if you add that to the remains in New York comment, right?
Yeah, it means we're missing a big part of the puzzle.
Well, and so looked into like, okay, what is somebody, I would never say the word stomping ground. Like I would not use that in a context. And so I've gone through like internet searches, like searching for context of why somebody would say that, right? And to me, stomping grounds, it is like where you would feel free to run rampant, right?
Yeah, I think you're right, and I think that is the context from the way he used it in the interviews. I think he is framing everything in a pretty specific context where he's talking about that's where I used to do things. Whether you want to consider that, rape, murder, kidnaps, or bank robberies, or buried
Fires.
things, or fires, exactly. Like,
One of the problems I have with that though, and one of the problems that I had like originally with it was that you've got the situation where I think he lived in Utah briefly, then Washington, different parts of Washington. And it's not until right before he goes into the army that he moves with his family across the country to upstate New York, right? But
right.
then he's immediately going into the army and his family immediately moves to Maine. All right.
Yeah.
So, that doesn't bode with his statement that that's his stomping grounds.
Yeah, no, I agree with you. And that's sort of what sends me down these rabbit holes where, and I know you notice it. What I'll do is I'll start gathering these hundreds of missing people's cases and I'll gather these weird anomalies. And like, the
You
crazy
start
part
on
is,
one end and I start with one case and I'm like, okay, one case. And you're like, here's 1,000 more.
well, but here's how that here's what I've discovered about him. I've discovered that the FBI, everyone who's written about him, and all the people who think they know what they're talking about with Israel Keys are more than likely wrong.
Including some of our previous theories.
Absolutely. Like I am including myself in that. And so here's what I ran into there. Somebody asked me a question on a social media direct message, and I haven't addressed it, but I guess it came from some other podcast. I don't know what the other podcast is. That he just, I think it's a he. It's a pretty generic name, but I'm just going to say the person asked me, why do I think serial killers aren't caught today? And they laid out like this idea from their perspective that it's because we catch them early and we catch them when they're just rapists and burglars and DNA and blah, blah, blah. Here's my opinion on that. And this is just my opinion. It's not actually the podcast opinion. It's not anything to do with Meg's opinion. You're free to give yours after I say this. I don't think that technology is doing what people think it's doing in terms of these serial killers. And I say this as someone, as Meg mentioned, there's a lot of times that we will sit And when I have nothing else to do, or if I have some downtime, like, because I go and do movie stuff, and I will sit for 10 hours a day waiting to do 10 minutes of something because someone tells me to, and they pay me to be there. So when I have that downtime, I scroll through unidentified persons cases and missing persons cases, and I look at, for no good reason that I could explain to you, dozens of cases in a day. And some of them I'll go deeper, and some of them I don't right then, but I'll come back to them months later at something about those cases, whatever case it was, whether it's a found body or a missing person. I will get hung up on them, and I will be staring at them. The number of missing persons and murdered persons and unsolved murders hasn't changed. We're not catching serial killers, okay? It's not that we're catching them young. We're catching enough people that we think we're stopping things, but the missing people go on. The unsolved murders go on. The unidentified remains being found, and a lot of times of people who aren't even reported missing, go on. Serial murders are still happening in the United States. I heard the most interesting thing. I'm working on another project, and this came up in the course of the conversation, and it was absolutely 100% true. And I am now adopting it because I've modified it to be what I think is going on there. We've based essentially 40 years of profiling now. And by profiling, I mean behavioral analysis and our attempts to catch killers. We've based it on the people we caught. That would be like if a medical textbook was based on the opinions of the bottom 10% of the class of multiple medical classes, and the other 90% weren't even thought about. We base our knowledge to catch serial predators of all types on interviews with the ones who were stupid enough to do something to get caught.
And then talk about it.
So I don't think we know what we're doing when it comes to serial killers and serial predators.
It's really funny because I have the exact opposite opinion. And I don't know who's right or whatever. I actually feel like serial killers. You're right. Your logic is correct on, basing the profiling that we have off of serial killers that have been caught. Right. That's not the best way to do it, because since they got caught, inevitably serial killers that are going to be caught are going to be caught. There is a stereotype or that at any given time there are a double-digit number of serial killers operating in the United States, right? You're familiar with that, right? 20,
Oh, yeah.
40. I don't really know what the number is. And I don't think that's true. I have, but you have to keep in mind that I have a sort of a different opinion of what a serial killer is than what would be like the FBI's textbook definition of it. And like, they're the experts. So, they would be who to go along with. But, having Israel Keys and having researched him like I did, all the information we have about him, he gave me a whole new perspective on serial killers. Actually, I never had a perspective on serial killers before him, I don't think. But he's a confessed but not convicted serial killer of our generation, right? And he killed himself. So he slammed the book shut when he did that. And so that leaves, this infamy. There's not as many serial killers now. Based on the research I do see trends, and I do see things that need to be looked into as far as like geographically or like groups of victims, right? And without knowing who the perpetrator actually is, it would be impossible to say whether or not it's a serial killer operating, right?
Right.
Because I feel like sometimes what initially looks like a serial killer is not necessarily, they're a serial killer in the FBI's definition of it, but it's not the type of serial killer that like true crime is really all about. Because in situations where a killer acts like anybody having a bad day, losing their temper, being like extraordinarily irritated about something, when they act the way that they could act, anybody could act if they didn't have good self control, that's different to me than somebody who's like planning to kill people, right?
Yeah, I 100% agree with what you're saying there.
And so it's a lot of sort of nitpicking on my part. But I feel like a lot of people who would have been sort of like obsessed with, violence and, or even not obsessed with it, but just kind of prone to it, I feel like our advances in technology have really helped as far as occupying the brains of people who might be murdering otherwise.
Yeah, I tend to agree to some degree. So if we were to like scale them and say 0 to 10, and 0 is like some of the people that like I don't necessarily agree with as being serial killers. They have 1 to 3 victims, so technically they qualify, but really what they are is just asshole losers who they weren't preoccupied with killing. They just didn't really have a major issue with it when it came up, and as they get older, they've killed a couple people. That
Right. Well,
if it's the low end, go ahead.
Well, typically those type of people, you're going to see that they've killed like 3 people or more, but it's always like somebody they know.
Yeah, there's
And it's
some
always
distinct differences like that.
some sort of like something leading up to it, because the root of all murder, it comes from love, money, or revenge, right? Except, and so if you can point it to that directly, love, money, or revenge, more than likely the person is not a serial killer. Now, in some cases, serial killers will kill indirectly. They are killing for the motive of love, money, or revenge, right? But it's not the person that it's actually geared towards.
Okay, so if they're killing indirectly for love, money, or revenge, those people are on the bottom of my scale. Like, and I totally understand the people that you're talking about there. Those are in my 0 to 5 of my scale of 10. Okay, so then you get your Bundys and your Dahmers, even Israel Keys and some of those others. They actually don't fall at the top of my scale. Those guys are between like a 5 and a 9 on my scale. So the people that are immediately 5s, like they would include like your drug dealers, they would include like some of your mass shooters and spree killers. But the 9 on my scale is Samuel Little. Like he's a guy who was indiscriminately killing, if you believe the stories and you believe what the FBI has put together, dozens of women for one purpose. And so Bundy, Dahmer, those people were killing because they had something going on where they wanted to kill. Even Keys, he wanted to kill. I mean, he still had a rape motive, but he wanted to kill. With Sam Little being at my 9 out of 10, he had something else he was doing that consistently led to him murdering, and he was totally okay with it and also getting off on it. But from that 9 to that 10 slot, that last slot, I reserve for people we haven't caught. And those people are killing because they've made it their job.
And so you don't have anybody to put there?
We don't have, I mean, we have like, I can give examples of unidentified serial killers who fall into that like 9 to 10. A lot of it, if you look at the long haul trucker programs that have been out there where they're trying to identify those type killers, those guys have tailored their life around the ability to kill without getting caught.
Right. Yeah, that's insanity. So basically, I think that would be good, just to say that the 9 to 10 scale is
unidentified people.
Right. Keys is up there for me though. He was unlike he's not as like he's not what was initially sort of put out there about him, you know?
No.
Like cuz it was like, oh, the most meticulous like whatever serial killer and cuz there was a lot of information just sort of pouring out and if you just sort of skim off the top of it, a lot of that information had nothing to do with him actually. It was like his girlfriend was going to get plastic surgery and stuff like that. It wasn't him. But, initially it's like, was he modifying his appearance? Like, do you remember that? I don't know
Oh
if you
yeah,
remember.
yeah, yeah. Was he
And
getting some kind of plastic surgery to make it where he could be a more efficient killer? Like he
it
getting a
was
lap
like,
band so he didn't have to eat. There was all kinds of weird
it
stuff.
was like, and he just wasn't that guy. Like,
No.
he was very scary as far as like if you listen to his interviews, the way he talks about like how he picked by not picking the couriers, like, oh, it really makes it opens up this vulnerability that is a lot of times unseen, right? Because when you have a situation where you've got a jerk that kills people, it's a completely different thing where you've got somebody walking down the road in the neighborhood trying to pick out who doesn't have a dog and who doesn't have kids, right?
Yeah.
That's a horrifying type of
That's what
thing.
puts him in that like category where I say like those are the 5 to 8s because he has made it like with Keys, it's not his job. He actually has other things he's really good at, but for some reason he's decided this is his number one hobby.
Yeah, he was just really messed up.
So
Um,
that's what brings us to today's case. We have we have a lot of people in the world who are experts in serial killers. I totally understand that that's a thing. Um, I I don't believe 99% of what they're talking about, but I picked something for today that I've gone back and forth over the years because there's been times that like I look at like the case of the Eastbound Strangler, the City murderer, or what Atlantic City serial murders, which was prostitute killings, the I-70 serial killer, not Golden State, not Green River. But I mean, in Green River, we know who that is now. Golden State's now solved. In the past, they were not. So people would get out there and like talk about theories of and even now they do it with like the Zodiac and whatnot. So I've developed this timeline for Israel Keys in my head where I can look at a case and go, okay, is that his? Is that not his? And there's one that I was never able to like completely rule out, and it comes from. Okay, so first of all, it's a series of murders that happens. It's up in the Northeast, but it's not in the right state. It has a suspect who doesn't make sense, and he's going to be the focus of what we're talking about today. And then it has like one of those experts that pops up. And the reason I bring this all up together is because that expert hosted one of the first specials about Israel Keys, which was Dark Minds, and I used pieces of that in our season one. But the case that we're talking about today, there is a name in this first part of it, and then it sort of spills over into this theory. So to tell this as a story, we have to sort of start in October of 1996, and this is in Massachusetts, by the way. Specifically, this is in Fitchburg, Massachusetts. In October of 1996, a passerby discovered the body of a woman on the side of a road in Fitchburg, Massachusetts. Her name was Teresa Stone. Have you ever heard of this murder outside of us talking about it here, Meg?
no, it was. I've only heard it from this.
Okay. Her case goes unsolved for a really long time. In fact, the way that her case is written up, she doesn't even have a real suspect until many, many years later. And From what I could find in Seacoast Online, and the rest of this is mainly, the sources today are mainly like the court documents. They announced in 2008 that she had DNA on her. They considered her death to be the 1996 death of Teresa Stone to be a rape homicide. And they get a DNA match, but the DNA match doesn't result in a trial until 2012. So 16 years later, in March of 2012, a jury there convicted a man named Alex Cesny of murder in the first degree and aggravated rape in the death of Teresa Stone. So where I'm pulling this from is actually his appellate documents. So he's been convicted, and from 2012 to 2015, he sort of makes his way through the court system with various arguments as to why he should not be convicted of this crime. So here's their statement of facts. On October 23rd, 1996, the victim, Teresa Stone, and her daughter, who I'm not going to name here, spent the day running errands together, and they returned in the afternoon to the apartment where they'd been living in Fitchburg, Massachusetts. At approximately 7 o'clock p.m. that evening, the victim left her apartment to buy some groceries for dinner. And shortly thereafter, she visited a bar on Main Street in Fitchburg. She arrived alone. She stayed for about an hour, and she talked to a bartender there named Jesse Spencer. The victim then left the bar alone and returned to the apartment with the groceries that she had purchased. She told her daughter that she had received a ride from a man in a black truck who was waiting for her outside, but that she did not want to go with him. Sometime between 9:30 and 10:30 p.m., the victim leaves the apartment, and she tells her daughter that she's going to work a day, which is a temporary employment agency. So this is the last time that the daughter sees the victim alive. On October 25th, 1996, so 2 days later, the police respond to a phone call regarding a body by the side of the road in the same town, Fitchburg. They observe that there's a white female lying on her left side. Her face is down on the ground. Her pants and her underwear are pulled down to her knees. Her knees, thighs, her buttocks, and her lower abdominal area are exposed. At this point, the body has a light coating of leaves over it, and its lividity appears consistent with the position in which it is found. So essentially, she's been laying here since death. Police discovered what appeared to be a condom wrapper underneath or in the vicinity of the body. And the body is identified as belonging to the victim through fingerprint analysis. The cause of death was strangulation by ligature. The autopsy revealed that 2 of the victim's teeth had been broken. She had blood in her mouth. She had injuries to her eyelids, nose, neck, left shoulder, right clavicular region, right arm, right metacarpal, and her right thigh. So when it goes to trial, the Commonwealth and the defendant, who in this case is a guy named Alex Cesny, that's Scesny, they stipulate to the following. After the victim's body was discovered on Kinsman Road on October the 25th, 1996 in Fitchburg, blood samples and vaginal and anal swabs were taken into evidence. This material was sent to the Massachusetts State Police Crime Lab for DNA testing. These tests generated DNA profiles, which were made part of a DNA database. In 2008, for reasons completely unrelated to the investigation of Teresa Stone's death, Alex Cesny's DNA profile was entered into that system. Sometime after that, a link was believed to have been established between Alex Cesny's DNA and biological evidence taken from the crime scene of the death of Teresa Stone. At a later date, Alex Cesny provided further DNA samples for comparison purposes. The rectal swab taken from the victim contained sperm cells, and the DNA profile generated from the sperm matched the DNA profile for the defendant. The probability of a randomly selected unrelated individual having a DNA profile matching the major profile obtained from the rectal swab was 1 in 13.2 quadrillion of the Caucasian population. Okay, so just so I understand that, if you don't mind helping with this.
It's impossible that it wasn't him.
Okay. That's what I understood it to be when they get into these quadrillions, because
Well, you're only at billions of people on Earth, right?
right.
And so it'd be like billion, trillion, and then maybe quadrillion. I'm not even sure like where that falls, but it's like 4 or 5. I don't know. And we're talking about like 4 or 5, either 4. Oh, I think it's quadrillion, right?
Quadrillion.
Okay, so that's after trillion. So you're looking at.
I had to look it up. I was like, when I saw that, I was like, that's just a number they make up.
A million billion is a trillion, right?
Right.
And so a billion trillion is a quadrillion.
Yeah, no math. The definition of it was 1,000 raised to the power of 5.
Oh, 5, not 4. Okay, so clearly this is not a number we have to deal with. So my point is,
it is a 1 with 15 zeros behind it.
Okay, well, so there's what, probably around 10 billion people on Earth.
7 to 10 billion people.
If it was a 1 in 13 quadrillion chance, that means like there's not even enough people on Earth for there to have been, because it would be, you'd have to have for there to be another person to match that particular sample, the way the profile was obtained and how it looked, you would have to have 26 quadrillion subjects in order for there to be 2 of them. So it's impossible that it's not him. It is. I don't know why they don't put it is certainly him, but like it is safe to say it is certainly him.
Okay, so that gets put into evidence, and then here's where they go next. Upon examination of the victim's body, there are a number of small red and brown stains that are noted on the victim's exposed skin and her clothing. A screening test for the presence of blood is performed on the stains from the victim's lower pant leg and her sneaker, as well as stains from her right hip and her right thigh to her left knee area. So on her body, there are multiple areas they are testing to see if a test will indicate it's positive for blood. The stains test positive, indicating that there's a possibility or a probability that blood could be present. The stain on the thigh area, so the thigh to knee area of her, it's from what I understand, it's her right thigh to her right knee. It's submitted for further testing, and a confirmatory test for human blood is also positive. So they generate DNA profiles from the stains on the sneaker, the hip, and this thigh to knee area, and it indicates that there's a mixture of DNA from more than one source. These small red-brown stains that they've noted and that they have tested, turns out they're blood and they have DNA in them, but it's not just one person's DNA.
Did they clarify that?
The defendant matches the major profile in the DNA mixture on the hip.
Is it her blood that's mixed with it?
They were getting there. It's so complicated. When I get into reading all these words, you're going to have to explain a little bit of it. But go ahead.
No, you go ahead, because I want to make sure I say the right thing.
Okay. So the probability of a randomly selected unrelated individual having a DNA profile matching the DNA they could pull from this particular stain area, which is her hip, was approximately 1 in 1.366 billion of the Caucasian population.
All right. So in that case, in the entire world, you're looking at like less than 7 to 10 people would match that.
Right.
So,
But it does specify Caucasian population.
oh yeah, okay. So I don't know the breakdown of that. That's another situation where it's him.
Okay, so it gets lower as we go. The defendant also was included as a potential contributor to the DNA mixtures on the sneaker and the thigh to knee area. The probability of a randomly selected, unrelated individual having contributed DNA to the mixture was approximately 1 in 61 people of the Caucasian population for each of those
Okay,
two stains.
so 1 in 61 is that's a way higher probability that it could possibly be someone else.
That's what I was thinking.
Okay, because it's just 61, not million or anything like that.
It's just 61.
So for every 61, whatever characteristic they gave it, I don't know if they said Caucasian in that. For every 61 people, one person out of 60 of those 61 people could possibly match it.
Okay, so and it is Caucasian population on that.
Okay.
So the next thing that they do male specific DNA testing on 3 areas of the victim's underwear. In the first area, a partial male DNA profile was generated that matched the defendant. The probability that a randomly selected individual would match the profile was 1 in 2 of the male population.
Yeah, so that's really low.
Yeah.
I mean, like literally half of the male population could be that contributor. I don't know what they were testing there.
These are underwear that they're testing.
Well, I know, but I don't know
I gotcha.
what what sequences
generated
they were
the
looking
DNA,
at
yeah.
or whatever. Yeah.
So in the second area tested, a partial male DNA profile was generated and it did not match the defendant.
Okay.
In the third area that they tested, of these 3 areas of the victim's underwear, no male DNA was found. A screening test for the presence of blood on 3 red-brown stains found on the underwear was positive. Did you have a question there?
You said that there was no male DNA found of the 3, but you're saying the third one didn't have male DNA.
The third area of the 3, there was no male DNA found.
Okay.
So then they do a screening test for the presence of blood, and it says there could be blood. They don't find seminal fluid on the victim's underwear. So it suggested that the victim had not pulled up her underwear and pants after the semen in her rectum had been deposited.
All right,
So,
and I just want to clarify that the earlier number where it was like 1 in quadrillion or 13 quadrillion or whatever, that was from the semen collected that matched him, right?
yeah, this was from a rectal swab, the 1 in 13.2 quadrillion. There was a DNA profile for the defendant found based on semen removed from the rectal swab. Okay, so Jesse Spencer was a bartender who was working at the Brauhoff Bar. This is the bar in Fitchburg. And she was working on the night of October the 23rd, 1996, which is the night of the victim's disappearance. In 2008, police showed Spencer several photographs and asked her whether she recognized any of the persons depicted in them as customers of the bar. She was shown a photograph of the defendant, Alex Chesney, and was pretty certain she recognized him. Overall, 4 of the 6 photographs she was shown were of men she recognized from the bar. The defense concedes at trial that Alex Chesney, the defendant, has had sexual intercourse with Teresa Stone, the victim, but they argue that the intercourse was consensual. The defense stresses that the stains on the victim's hip, knee, and sneaker contain a mixture of DNA from more than one person. And they argue that any potential contribution by the defendant to the DNA to these stains was not necessarily blood, but could have been some other bodily fluid transferred onto Teresa Stone's body during their sexual encounter. The defendant also presented evidence at trial suggesting that 2 other men may have been responsible for the victim's death. So this is known as a Sadi defense, but it's more specific than that. A Sadi defense is some other dude did it. In this instance, they get a little more specific and they say one of these other dudes probably did it. There's a man named Everett Carlson and a man named James Weber. James Weber is the victim's former husband, and he is the father of her daughter. Both of these men are excluded as sources of the sperm on the rectal swab taken from the victim. They're also excluded from the DNA mixture in the stains on the victim's sneaker and the right thigh and left knee. So when I say right thigh, left knee, the way that she was laying, her legs were together. Her left knee was touching her right thigh, and there was a stain that extended across both. So it's on the inside of her right thigh and the back of her left knee. The major male DNA profile from the other stain on the victim's right hip did not match either of these men. So Weber ends up excluded as a source of the partial male DNA profile generated from the stains on the first area tested on the victim's underwear. But Carlson was included, meaning...
Which is not... Go ahead.
Well, the way they say that means his DNA profile matched the partial male DNA identified in the area of the underwear.
It actually just means that he couldn't be excluded. And that is where you've got the 1 and 2, right?
Yes.
So clearly you've already got the defendant matching, and then you've got two people, possible contributors.
Yeah.
And so one of those two would more than likely match. It actually lines up with the statistics there.
Yeah.
It doesn't mean it's him. It just means for every 2 men you look at, half of them, one of the 2 are going to match that. So it's basically like, unless they had just both been excluded, it's kind of useless. But anyway, go ahead.
So the second area, so there's 3 areas tested on her underwear. The second area that they pulled a DNA profile from that was male, nobody matches. Not
Right.
Cesny, not Weber, and not Carlson. They're all excluded as the sources of the male DNA detected in the second area tested from the victim's underwear.
Right. Okay.
So we have something there that isn't these guys, but they state kind of obscurely that it's not seminal fluid. We don't know what it is.
But it did test as male, right?
It is male.
Okay.
And it does not match the 3 of them.
What about the third stain?
The third stain has no male DNA on it.
Okay. And so basically, her underwear didn't have any of the guys, the quadrillion sample. The underwear didn't have any of the quadrillion on it.
No, her underwear and
yeah.
So here's how that it sets that up. I maybe didn't explain it since I'm kind of speaking in like dry language.
Yeah.
They're saying, okay, it doesn't make sense for him to have this quadrillion sample from their consensual encounter because she never pulled her underwear or pants up. He's the last one.
Exactly.
Because that rectal sample would have spilled over.
Right.
Correct.
Yeah, that makes sense, actually. I mean, the other stuff is probably just stuff that's on your underwear. I mean, I don't know what it is, but it could be from previous encounters. It could be from somebody folding the underwear. I mean, if it's not seminal fluid, DNA is in everything.
Yeah.
Right. I mean, it could be saliva, it could be skin cells, it could be all kinds of stuff. And I've never seen like how many washes does it take to get DNA out of something, right? I don't know. As far as
I can't go down that rabbit hole right now. Like I so want to. I'm thinking like I need to start Googling that, but it would just be I'll be lost.
And so this case is kind of all over chronologically because it was like, it happened in 1996 and then there was a CODIS hit, or they don't specifically say it was a CODIS hit, but basically the sample was put in from her murder. And then when he committed a different crime, his profile was put in, and that's how they made that connection, which is the entire point of CODIS.
Yeah.
And so with all that information that they just gave, so you've got the 1 in a 13 quadrillion sample. You've got him saying that they had consensual sex to offset that. However, you don't have it lining up as if it were consensual sex. So the other, I mean, statistics are what they are. And so it actually illustrates it in this case. But I feel like the evidence was pretty strong from what you just read.
Yeah, I mean, I felt like it was too, but there's always a wrinkle, and the wrinkle here is this is the appellate document. So there's a whole thing going on that I'm going to talk about, and there's so much more to this guy. But this is the first and probably 2 episodes about him, but this one right here, this is from the appellate document, which means that the defense wrote this, and then someone decided on it at a higher court. So where we get into the higher court part, what we have next is the procedural history, which is, it's short. The procedural history, as far as this case goes, it's just a couple sentences, but it's explaining to readers from the outside, like how it came to be in front of this court. So in 2008, the defendant was indicted for the murder and aggravated rape of the victim. As indicated in March of 2012, a jury convicted the defendant of murder in the first degree on the theories of deliberate premeditation, extreme atrocity or cruelty, and felony murder. He was also convicted of aggravated rape. So you can infer from what they're implying here that there's multiple theories as to how this may have happened because of the evidence presented. They're not entirely sure if it was premeditated, but the jury bought that it was, and they also bought that it could have been in the course of an aggravated rape. This death occurred, which makes it a felony murder. And then it says the defendant filed a timely appeal of his convictions, which we consider here. So that's the whole of like sort of the procedural history or the facts of what they're looking at. This gets into the discussion portion of this for the court and what they're going to decide on. The first point is the defendant claims there was insufficient evidence to prove that he was the perpetrator of the victim's murder. So he's going after the sufficiency of the evidence. And he claims that it's also insufficient to prove that he committed aggravated rape. So they're attacking both the murder and the rape charges, because even if you get around the murder charge, you still are left with this rape charge, which makes it a murder. So the defendant does not dispute that the DNA from the rectal swab taken from the victim established that he had intercourse with her, but asserts that there's no evidence to prove that the sexual interaction was not consensual. He also contends that the additional forensic evidence was ambiguous, inconclusive, speculative, and ultimately insufficient to prove that he murdered the victim. Apart from this forensic evidence, the Commonwealth provided no evidence connecting him to the scene or to the murder. To support his argument, he notes the evidence that the victim was a prostitute and therefore had consensual sex with men, and further, that the autopsy report revealed the victim's external genitalia and anus were normal without any sign of injury or trauma. Okay, so that is what he lays out as his first point of contention in the appellate documents. That's pretty standard, don't you think? Say
Right.
that they didn't have enough evidence?
Right. And he probably actually was right.
To some degree, yeah. The court says, with respect to the charge of murder, the defendant's claim fails. The trial evidence...
Rape.
Yeah.
Okay.
The trial evidence considered in the light most favorable to the Commonwealth would allow the jury reasonably to find that the defendant had sex with the victim as he concedes, at or near the time of her death. The red-brown stains on the victim's body and clothes were, or certainly included, the defendant's blood. The victim had not pulled up her underwear and pants after having anal intercourse with the defendant or after the defendant's blood was deposited on her body. The victim died from strangulation by ligature. She also suffered significant injuries to her face, as well as to her arm and her thigh, and she could have encountered the defendant at the Brauhof bar on the evening or night of October 23rd, 1996. Based on this evidence, the jury reasonably could infer that the defendant had sex with the victim and then strangled her. They cite a 2008 case decision called the Commonwealth v. Perkins, and they specifically quote, because death had occurred while the victim was lying on her back and because no sperm cells were found on the crotch area of her panties, death probably occurred after intercourse and before the victim could pull up her clothes such that her panties would collect sperm cells draining from her body. This is a sequence of events that supports a determination that the defendant acted with deliberate premeditation. Secondly, they mark up a 2000 case called the Commonwealth versus Bergoli. And the quote from there is, evidence of death by strangulation supported an inference that the victim's death was not instantaneous, but the result of pressure applied to her neck until she lost consciousness, which warranted finding that the defendant acted with malice and deliberate premeditation. Then they go back to the case at hand and they say, moreover, the extent and severity of the victim's injuries permitted a finding of extreme atrocity or cruelty. That's specifically referencing the fact that her teeth are broken. It indicates to some degree that her face has been assaulted. Then they use one last case from later. So this is happening in 2015 on a 2012 trial, but they use a case from 2014, which was the Commonwealth versus Scott. And these are all Massachusetts rape cases. Some of them are I think all of them might be rape murder cases. And the quote from there is that evidence that the victim was raped and strangled with significant injuries to the head, skull, and face support a jury's guilty verdict of murder in the first degree under the theory of extreme atrocity or cruelty. And they cite one last case from 1979, which is the Commonwealth versus Lattimore. And considering evidence in the light most favorable of the Commonwealth, we ask whether any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. The gist of what they're saying here is there's enough evidence in this basket of a trial that it seems like the defendant did this. And like the jury wasn't wrong to consider that the defendant did this with premeditation and with atrocity and cruelty. Here's where they deviate. Where do you think they deviate?
They're saying that he didn't rape her.
That's where we get to. So,
I mean, there's really not evidence of it because he spoke up and conceded to the fact that, and it's actually just like sort of a legal strategy, because I would argue that if you have sex consensually that ends in your death, you may have revoked the consent. It's not funny. It's just this is so bizarre to me. Because
it's a crazy conversation to have. I agree.
But as far as like the legal, because the defense attorney here, he is not in any way taking up for or excusing his client. Defense attorneys represent how the law is to be applied to people who have been charged, or in this case, convicted of offenses, right? So
Yes.
It's not to lessen it against the victim. It's just to, when a defense attorney practices law, they've got to present arguments to these appellate courts. And from this, other case law is made, right?
Absolutely.
And so while most of us, myself included, I feel like once you have a first-degree murder charge, most of the time, you're going to be spending the rest of your life in jail. Yes, occasionally there'll be a death penalty sentence, but for the most part, it's life in prison without the possibility of parole. That's it for first-degree murder, most of the time. And it seems a little bit like kicking a dead horse to, appeal, which they were appealing the guilty murder finding as well, right?
Yeah, the murder conviction is what they're appealing.
But, in doing so, they're also appealing the rape.
Correct.
And because he stipulated at trial that they had sex and it was consensual, I don't hear the state, I haven't read that document, but I don't hear the state making the argument for where does the consent end there, right? And that's a whole different situation, but go ahead.
Okay, so and they don't outright state what I'm about to say, and then I'll get back to stating what they outright state. he's sort of making a statement against his own interests as part of his defense, which is it is not in his interest necessarily to say that he had sex with her. That would be in his interest if all they had was the rectal swab would be a little convoluted if that was it. The problem comes about with his blood being there because it's real hard to say that, like, we're doing something consensual and then there was an accident and then all these injuries happened, because he also had some kind of injury. And what I think they end up implying here is that her teeth get broken by his hand, and his hand has an injury that drips blood on her body, which that's the problem. The body is found in a state where if he had just had sex with her and she went on about her business, when she pulled up her pants and walked away, all that blood and everything would have changed position. But instead, you have her lying prone on a road with his blood and his seminal fluid not moving from the places that it was deposited, essentially. They do agree with the defendant that the evidence presented was not sufficient to support his conviction of aggravated rape. This court has established that the essence of the crime of rape, whether aggravated or unaggravated, is sexual intercourse with another compelled by force and against the victim's will, or compelled by threat or bodily injury. Here they reference the Commonwealth versus McCourt from 2003. And basically, they state in quotes, absence of consent is an essential element of the crime of rape, whether aggravated or unaggravated. And then they use the holding from Commonwealth versus Sharamond in 2012, which is here the evidence from which the jury could reasonably infer lack of consent is also lacking, meaning the evidence is not presented to say that consent is not there. Although the victim was found with her pants and underwear pulled down to her knees, the clothing is intact and there are no evidence of rips or tears. And they're contrasting this against an earlier holding in 1989, which is the Commonwealth versus Tavares, which the evidence was sufficient to support conviction of aggravated rape, where, inter alia, the victim woke up without her pants and her blouse and bra were torn. In addition, the autopsy report establishes that the victim's external genitalia and anus were normal and no injuries are noted in these areas.
Yeah.
With a contrast to this, the Commonwealth versus Miller in 2001, evidence that the victim's thighs were bruised and her vaginal opening had been injured, together with other evidence which was sufficient to prove beyond a reasonable doubt that the defendant had raped the victim. So that's the quote from Commonwealth versus Miller in 2001. So where they get to here is there also is evidence presented by the state that the victim had worked as a prostitute in the past. Further, that the victim's daughter indicated she would not be surprised if the victim was going to, quote, make some money the night that she was murdered when she left with the man in the black truck. And the victim's body was found about 1/2 mile to 1 mile from an area known to be a place that prostitutes would frequent with their customers. So the Commonwealth's case against the defendant was found to be entirely circumstantial. Although the victim ultimately suffered severe injuries that the jury could infer were inflicted in connection with her murder, there was no evidence favoring the inference that the defendant raped the victim before killing her over the inference that he had consensual sex with the victim and then killed her. It's weird that they made a successful argument here that does absolutely no good for him.
Well, they overturned that conviction, though, right?
Yeah, so they pull from the Commonwealth versus Cannon from 2007, and they say when the evidence tends equally to sustain either of two inconsistent propositions, neither of them can be said to have been established by legitimate proof. So his attorneys did sort of a genius thing by admitting that he'd had sex with her, because ultimately here, and accordingly here, because the evidence is insufficient to permit a finding of lack of consent beyond a reasonable doubt, the defendant's conviction of aggravated rape must be reversed, and the jury's finding that the defendant was guilty of murder in the first degree on a theory of felony murder must be set aside. So, okay. People have asked me before, and I've seen it asked of other people, why did they charge 5 counts of murder for one incident?
This is why.
This is why they do that. Okay, they charged that he had killed her by premeditation. They charged that he had killed her by extreme atrocity, and then they charged a felony murder, meaning he killed her in the course of an aggravated rape. The aggravated rape gets overturned, which overturns the felony murder by proximity, because without one, you can't have the other. So what we're left with here is he guilty of premeditated murder, or is he guilty of murder with extreme cruelty? So the next part of their discussion, the defendant has some expert testimony that was brought up. He argues that the trial judge abused discretion in admitting the opinion testimony of Deborah McKillop, who is a criminalist with the Massachusetts State Police Crime Lab. This is convoluted, but here's what he says. At the time the victim's killing was initially investigated in 1996 is when she was a part of this. At trial, the defendant objected to two portions of McKillop's testimony. The first portion was that based on her experience, there would have been some expected drainage located on the victim's underwear if the victim had pulled up her underwear following the deposit of semen into her rectum. Two, the second issue, that McKillop testified she would expect to see some interruption or disturbance of the stains on the victim's body if the victim had pulled her pants up after the stains had been deposited, which is what I was mentioning earlier. Like a smear, something would happen to keep those stains on her skin from being so pristine. These are the ones that are in the defendant's blood on the victim, and the mixed stains, where it's both of their blood. That basically something should have happened if she had changed her clothing after their encounter. The defendant argued that McKillop's opinion testimony in these areas exceeded the scope of her qualifications and failed to meet the foundational requirements for expert testimony. He further claims that because this testimony was a pivotal piece of the Commonwealth's case, its admission becomes highly prejudicial. So evidence can be a lot of things. It can be probative, meaning it's, something that should be brought up, or it could be prejudicial. The defendant is making the argument here that because of the way she testified on those two facts, that there was no way the jury could look at that and not find him guilty. But he's also arguing that she's maybe not an expert in that. So here's what the High Court says. They say a trial judge has wide discretion to qualify an expert witness and to decide whether the witness's testimony should be admitted. This is Commonwealth versus Frangipane from 2001. And then they use a second holding in Commonwealth versus Avila, which is the admission of expert testimony will be reversed only when it constitutes an abuse of discretion or other error of law. The judge's decision to admit testimony will not be upset on appeal if any reasonable basis appears for it. And there was a citation in this originally, but for some reason, it's some case that had other stuff occur in it. So they've removed it from my copy of this. In qualifying an expert witness, the question for judicial decision is whether the witness has sufficient skill, knowledge, and experience in the area of his training to aid a jury. And that's from a 1990 case called the Commonwealth versus Mahoney. McKillop testified at trial. She had been employed at the crime lab from 1986 until she retired in 2007. That's a pretty long time to work for a crime lab. After 1 year working as a criminalist in toxicology unit, she transferred to the criminalistic section, where her expertise entailed going to crime scenes to collect evidence, as well as working on evidence submitted into the crime lab. The cases she worked on included fatal, non-fatal shootings, beatings, stabbings, sexual assaults, and involved a variety of evidence, including identification of body fluids, blood, saliva, semen, as well as collection of trace evidence such as hair, fibers, paint, glass, or gunshot residue. Later in her career, McKillop was a supervisor in the criminalistics unit for approximately 9 years, and she supervised both the criminalistics and the DNA units of the crime lab for 2 years. These were the 2 years before she retired. At the time she testified at trial in 2012, McKillop was the forensic manager of the crime laboratory of a county sheriff's office in California, where she was responsible for overseeing the crime scene response unit, the biology and DNA unit, the firearms unit, and the latent print analysis unit. She also had bachelor's degrees in chemistry and environmental studies from the University of California in Santa Barbara. The challenged opinion testimony concerning what she would expect to see if the victim had pulled up her underwear and pants following intercourse and following the deposit of the red-brown stains on her body clearly was based on this extensive experience. So the High Court here rules the judge did not abuse his discretion in admitting this testimony. They reference Commonwealth versus Rice, which the holding was in 2004, that there was no abuse of discretion in permitting state police chemists employed at a crime lab to testify to opinion concerning how long sperm may be found following ejaculation based on training and experience. They also reference the previous case, which was Frangipane. A social worker witness there was allowed to testify they had extensive training, education, and experience interviewing and treating sexually abused children, and that the judge had discretion to allow the witness to opine concerning dissociation and recovered memory and the fact that victims of trauma may experience them. The witness was not required to be a medical doctor in that instance. And then there was another case that they compared it to, which it was error to permit a social worker witness to testify about how trauma victims stores, retrieves, and dissociates traumatic memories because opinions concerned physical functioning of the brain. So that subject matter area was proper for a medical doctor, and it exceeded the abilities of a social worker. In this instance, with regard to McKillop's testimony, the court rules that the trial judge did not abuse their discretion in allowing that testimony. So you would think at this point, like, this case is pretty much over, right?
I can only hope.
This guy's case gets so much weirder. And this is not even like the half of it. That's the weird part. So there was another issue brought up, which there was a substitute medical examiner. The medical examiner who performed the autopsy on the victim retired approximately 12 years before the defendant's trial took place, and a substitute medical examiner named Dr. Henry Niels testified at trial regarding certain findings in the autopsy report that the victim's teeth were broken off, that there was blood in the victim's mouth, and that there were injuries to the victim's eyelids, nose, neck, shoulder, clavicular region, arm, and thigh. He also testified to his opinion as to the cause of the victim's death. Now, during the trial, the defendant did not object to any of the medical examiner's testimony or to the autopsy report or the photographs from the autopsy being introduced into evidence. Now the defendant's trying to argue that the admission of the autopsy report and the substitute medical examiner's testimony about the underlying findings from the report violated the defendant's constitutional right to confrontation. Because there was no objection to admission of the report or testimony at trial, they're reviewing it for a substantial likelihood of a miscarriage of justice.
And they didn't find one, right?
It doesn't appear that they do. I mean, they basically disagree with the defendant for a number of reasons. The autopsy report being prepared by a medical examiner who is unable to testify is listed here as constituting inadmissible hearsay whose admission violates the defendant's right of confrontation under the Sixth Amendment. They're making a constitutional issue out of it.
I wonder what the difference would have been if he had objected at trial.
I actually think if he had objected at trial, I think it would have been a problem.
See, I don't know, because it doesn't seem fair, like from a legal point of view, or the justice system. It doesn't seem like it would be a good idea to have it be that, like, if an expert, like in this case, the medical examiner, or if they retire, then like none of the evidence they use can come in. That doesn't seem like that would be good.
No, I mean, those documents are sort of living documents anyways. They're not, I mean, they're subject to interpretation, but the cool part about that is you're able to confront who's offering the interpretation. And you're also able to bring your own witness to offer their interpretation.
If you're going to put on a defense, right? And so, yeah, there are ways around it. I feel like, we've talked about before, the importance of the objections at trial, right?
Yeah.
From the defense's point of view, because if you don't object to something during the trial where the trial judge has the opportunity to hear what you're saying and make a decision, the upper court will not address it unless, like you said, it is like a tremendous miscarriage of justice. And that would be like, a completely different outcome on the case, basically.
Yeah, we went through this like series of domestic violence cases in North Carolina a couple years ago. You and I had multiple episodes where we talked about Brad Cooper and Jason Young. We talked about Michael Peterson, and one of the things I noticed, and some of those I've like live streamed, some of those I was sitting there. One of the things I noticed is like a lot of the defense attorneys in those type cases, they will object to everything.
And they're
They
making
will-
a record.
Yeah, they're really not objecting with any super great purpose. They're making a very specific record of what they think along the way, and they're giving themselves the opportunity to create a document similar to what I'm pulling from today.
Right. And so the best way to like kind of think about that is, we have judges in, district or superior court. All states have sort of a different, they're similar, but they're different. But the judge is going to do basically whatever they want to do based on their interpretation of law or not. Right. It's their courtroom. They sit there diplomatically and they're in charge. And it's not always fair. Right. But whatever they say is going to go until it would be overturned by a higher court than them, right? That's one of the reasons, like, who we elect as our like first judge, whether it's district court or superior court, or whatever it is for where you live. It's so important who those people are, right?
And so many people don't even know who they're voting for when they vote.
They really don't. But like when you go before that judge, whatever they do. So if a person who is qualified but not interested in, being a diplomatic judge is elected, every single thing they do on the stand is going to be a problem, right? Because you literally can't do anything about it until you go on to an appeal.
Yeah, you can't. And it depends on which direction you want to take here. I guess I could take judges are people too. But they hold a high degree of authority and power in our criminal justice system.
And sometimes it's
misplaced
or misused. But, if you don't object to a decision they've made, like, saying, now my understanding was they did object that she may not be an expert, right? One of the people who testified. Okay, so that's an objection that the appeals court would then rule. Now, my first thought is anytime it's the trial courts, anytime the principle of the matter being appealed is up to the trial court's discretion, those rarely get overturned. Rarely. Okay, because of what we just talked about, how their courtroom is their kingdom, so to speak.
They're trying to empower the judges, and honestly, if we second guess everything that judges, they're there to provide sort of a gatekeeping so that the system doesn't get clogged. They're supposed to do their job correctly.
Right. And they're people, so they don't always get it right. But in this case, just sort of listening to, how the procedural history has gone, this is pretty standard. Now the rape part of it is a little bit different than what I'm sort of used to reading, but it doesn't make a difference. But, the first thing you want to do at trial is, there was no crime, and then somebody else committed the crime. It wasn't my client. And then in this case, it was that the sex was consensual. And now, they're moving along. And so this is just like murder appeal 101, right?
It really is. Well, they can. So we're kind of winding down on this part of this story, but there's a couple points left here I want to make about this. So we're left with this idea of a substitute medical examiner. The defendant makes this argument, and the court rules against the defendant for three very interesting reasons. So the defendant has argued that the admission of the medical examiner's opinion plus all the underlying facts and findings related to this. So that's all your autopsy photos, your autopsy report, everything going on here. The defendant argues that this creates a substantial likelihood of a miscarriage of justice because the Commonwealth was relying on the evidence about the victim's injuries to prove the defendant inflicted them and then bled on the victim. The defendant claims that this was critical evidence because there was no other evidence connecting the defendant to these injuries, and that the overall evidence of guilt was not so overwhelming that it would nullify its effect. The court disagrees. Three reasons. The first is the defendant used they massacre the defense attorney with this, but the appellate attorney, like it's masterful. It's brilliant how the court writes this up. First, the defendant used the evidence related to the autopsy findings and Neild's testimony as a substitute medical examiner in particular to help build the defense. Specifically on cross-examination, the defendant elicited testimony from Neild's about the observations that there were no visible injuries to the victim's genitals or anus. The defendant then used the testimony to support the claim that the evidence was insufficient to prove the intercourse between the victim and the defendant was consensual or not. And defense counsel reiterated these points in closing argument. So the prosecution couldn't disprove that the victim and the defendant had consensual sex. So,
right, but they also couldn't, in this appeal, they couldn't use something to mount their defense and then try and get it thrown out.
That's why I said it was masterful. They cite a number of cases here, but the gist is you can't use what you want thrown out. The second reason is Neild's testimony about the findings in the autopsy report is cumulative of the injuries depicted in the properly admitted autopsy photographs, meaning those photographs are just, like I said, a living document. They're appropriate.
And they're not being, they weren't objected to, and they're not a source of appeal, right? And
correct.
So as long as they were corroborative of each other, then it stands to reason that it's all a living document.
Yeah. And so where they get to the final reason that they tell the defendant to stuff it on this round of claims is the autopsy report and Neild's testimony about the victim's injuries did not relate to an issue that was contested at trial. The defendant challenged the identification as the perpetrator of the injuries, but he didn't dispute the nature of the injuries the victim suffered. So ultimately, there's no substantial likelihood that there's a miscarriage of justice arising from this erroneous admission of the autopsy report and Neild's autopsy-related testimony. So the defendant's argument fails here. And then we sort of start to wrap up what they're doing in terms of they're running out of things to appeal. They're running out of things to get this guy out of this homicide. One of his last things, I think he's got two left here, he basically states that the defendant patronizing the Brohoff bar, that evidence should not have been admissible. Jesse Spencer testifies at trial that she was pretty certain, this is the bartender, she's pretty certain that the defendant had been a patron of the bar. Based on her examination of a photograph of the police, the defendant that the police showed her in 2008. The defendant argues that the testimony is irrelevant because Spencer was only pretty certain that the defendant had been a customer at a bar, and there was no testimony about when. So they don't bring up, they bring up, do you know this guy? Do you recognize him as being someone in there? They don't bring up, was he there that night? The defendant alleges that the erroneous admission of the evidence about when results in the unwarranted inference by the jury that both the victim and the defendant were present in the bar on the same night. So they rule. Go ahead.
Well, what did they say?
They say there's no error.
Well, because if he wasn't at the bar, then it actually makes it worse for him. Because the consensual sex came from the fact that he more than likely picked her up at the bar, or there was something else happening there, but it was all consensual. So that seems dumb to argue that, but whatever. Okay.
No, I mean, I'm with you. A lot of times with these appellate documents, what you end up with is there's a kitchen sink being thrown at the wall. They're literally throwing everything.
I would have a really hard time contradicting myself like that, but whatever. I mean, it is what it is.
Yeah. So, and another thing you have to remember is in these appellate documents, when they're talking to the defendant, because that's who they address everything to in here, the higher courts address the defendant. But that doesn't necessarily mean it's the same attorneys. It just means it's the same defendant, because it could be one person at trial, and very frequently it's a different attorney handling the appellate matters.
Right, because it's a completely different process, right?
Right. So they may not understand or be able to connect the dots, or to be able to get their shit together enough.
Or they may be willing to live with the result of what that means if it's found to be their way.
I mean, in this case, whoever is doing, and the name's on here, but when they're doing this, they are successful arguing the rape case. I mean, that, like, it doesn't do anything, but it's an argument that the court agrees with them on. So they're not barking up the wrong tree completely. Although they get to do that with this part. They get to the prosecution's closing argument being a problem. So the defendant contends that the prosecutor's closing argument is improper in a number of respects. The prosecutor unfairly disparaged the defendant's constitutional right to present a third-party culprit, misstated the law, engaged in improper vouching of evidence, and misstated the evidence. The combined effect of the improprieties, the defendant argues, requires a reversal and a new trial.
That's under discretion, right?
Yeah, this falls under discretion.
And so they didn't do anything about it, did they?
Well, so this is how, like, when I'm reading this, I keep having to remember this is a defendant's document. There's no question that the prosecutor's argument was flawed. Before reaching the principal focus of the attack, the defendant's third-party culprit theory, the prosecutor told the jury.
I'm sorry, you said it was a defense document, but you're reading the opinion, right?
I'm reading the opinion, which pulls from the defense document.
Right, okay.
This is
just to be clear, both sides have to agree on the record. So anything in the opinion would be agreed upon, right?
Mostly, except for the discussion, because what they do is they pull from the defendant's side, and then they either agree with it or disagree with it. So,
but I mean, as far as the state and the defendant go,
yes.
The appeal briefs are filed, it's in reference to a record that both sides have the opportunity to build and must agree on.
Yeah, the facts of the case, the record of the case, and the procedural history of the case are all agreed upon by both sides in order for the argument to remain in sync. Otherwise, there would be some serious disasters. So the prosecutor tells the jury this statement. I'm privileged and moreover proud to represent the citizens of the Commonwealth. That's who I represent. This is not a case about the prosecutor against the defendant. This is a case about the citizens and the defendant. Sometimes it's easy to forget, but you should know that the citizens of the Commonwealth, while defendants are cloaked in certain fundamental constitutional rights, and that's something we all embrace, the citizens of the Commonwealth are equally entitled to a fair trial. I ask you to hold on to this fundamental principle as you listen and deliberate later on. So the court decides this argument is problematic in two respects. First, the jurors, by definition, are all themselves citizens of the Commonwealth, and the prosecutor's characterization of his role as representing the citizens, they run the risk of suggesting that the prosecutor was representing the jurors as citizens against the defendant, and in that way, misrepresenting or at least confusing the jurors' actual role as neutral fact finders, charged with weighing all the evidence and determining whether the Commonwealth had proved the defendant's guilt beyond a reasonable doubt. So he's muddied the waters. Second, and more fundamentally, the Commonwealth in a criminal case is not a shorthand way of referring to individual citizens. It's not just the name of the party on the other side of the verses from the defendant. The Commonwealth plays a different role, and so does its attorney. Although the Commonwealth is entitled to a fair trial, and although the prosecutor has the responsibility to argue the Commonwealth's case forcefully, the fact remains that the prosecuting attorney is a representative not of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. The prosecution's characterization of the role in this case as representing the citizens of the Commonwealth against the defendant, and the prosecutor's emphasis on the rights of the citizens was at best inappropriate, and far better, left completely and wholly unsaid. The majority of the prosecutor's argument was devoted to attacking the defendant's third-party culprit defense. In its closing, particularly near its beginning, the prosecutor repeatedly sounded the theme that the defense was seeking to mislead, confuse, and prejudice the jury with the presentation of this defense by presenting information that lacked materiality and relevance, information that should not even be called evidence because it was lacking in those qualities. The opportunity to present third-party evidence is of a constitutional dimension because it's rooted in the right of criminal defendants to a meaningful opportunity to present a complete defense. That's a ruling from, I think it's Scott, Massachusetts, Commonwealth versus Scott, but they admitted it here because something has changed about it. Pursuant to the trial judge's rulings, the defendant here was fully entitled to present evidence and argue his third-party culprit defense based on James Weber and Everett Carlson, although the prosecutor was permitted to comment on the defense strategy and tactics, was not beyond the bounds in arguing that the strategy was intended to confuse. Although the prosecutor did not describe the third-party defense as a sham, as in Commonwealth versus Lewis, and although he did not say that the defendant or his counsel were intentionally misleading, as in the Commonwealth versus Fernandez, his repeated characterization of the defense evidence as irrelevant and immaterial information unworthy of even being called evidence, his complaint that it was unfortunate the Commonwealth even had to respond to it, and several rhetorical questions asking about the misleading and speculative nature of the third-party culprit defense. These comments and questions both misstated the law. The judge had specifically allowed the third-party evidence to be introduced as evidence because he considered it evidence, and verged on suggesting that the entire third-party culprit defense was improper and should not have been presented. Okay. They go through this part of the case pretty seriously. And if you're reading it and you're into reading legal documents, it's like a thriller because it almost seems like they're going to do something here. In determining whether an error in closing argument requires reversal, we consider whether defense counsel made a timely objection, whether the judge's instructions mitigated the error, and whether the error was central to the issues at trial or concerned only collateral matters, whether the jury would be able to sort out any excessive claims or hyperbole, and whether the Commonwealth's case was so strong that the error would cause no prejudice. So they're on board with you, by the way. They want to make sure that everything is lined up here post facto because they want to look at it and make sure everybody's agreeing on this record. If you don't have a good record and everybody's not agreeing on it, you don't know those things that I just said, which is whether there was an objection, whether the judge had made instructions, and whether the defense was able to somehow sort of balance out what the Commonwealth was saying. So the first three factors weigh in the defendant's favor in whole or in part. On the first, defense counsel objected both during and after the Commonwealth's closing. As for the second factor, the mitigation of the prosecutorial effort by the judge's instruction, the judge overruled the defense counsel's objection during the closing, but thereafter, the judge did give one limiting instruction after the prosecutor completed his closing in partial response to the defendant's objections. The instruction did help mitigate the prosecution's improper misstatements, belittling and mischaracterizing the evidence that was relied on by the defendant for his defense, although it would have been appropriate, as the defendant had requested, to explain more directly the prosecutor was overreaching, and in particular to have addressed specifically the prosecution's repeated assertions that the third-party culprit evidence was irrelevant and immaterial. Finally, on the third factor, the argument errors of the prosecutor related in whole or part to the third-party culprit defense, and that's the heart of the defense. The final factor they're considering here concerns the strength of the Commonwealth's case. Does the strength eliminate the possibility of prejudice arising from the prosecution's argument? The evidence leads us to conclude that the Commonwealth's evidence did so. The DNA evidence unquestionably pointed to the defendant, not Weber, not Carlson, or anyone else, as the person responsible for the victim's death. That is where there was no DNA evidence tying Weber to the victim, essentially none tying Carlson to the victim, and extremely little inkling of an unidentified possible person. The defendant was the sole person of the DNA located in the victim's rectum. As indicated previously, the DNA evidence from the rectum by itself indicates only that the defendant had intercourse with the victim close to the time of her death, not that he killed her. However, when this DNA evidence is combined with the absence of drainage on the victim's body and bloodstains, indicating the victim had not pulled up her pants and underwear after intercourse before she was killed, and the defendant's DNA is consistent with those bloodstains. And three, the fact that none of these fragile stains were smeared or disturbed in any way, suggesting the victim had not pulled up her pants or underwear, the conclusion that the defendant killed the victim seems almost inescapable. And they have a little bit more where they talk about some of the issues related to the jury instructions that came about, but it's not very interesting. And it's really just the defense throwing that last piece of the sink against the wall. In conclusion here, though, with respect to the charge of aggravated rape, the defendant's conviction is reversed. The jury's finding of guilt is set aside, and judgment shall enter for the defendant. But the defendant's conviction of murder in the first degree is affirmed. So that's how this concludes. He's still in jail. But I would never bring this case up if it didn't have something super interesting on it. And unfortunately, because I've used so much time on this, people are going to have to wait to hear about the rest of it next week. Do you think he did this, by the way? Do you think Szczesny killed Teresa Stone?
Without question.
Yeah, I know he did.
There's just no question about it.
Thank you for joining us. We are sponsored by LabbratiCreations.com. You can check them out at LabbratiCreations.com, and you can still use the code CRIMEXS for a fun pop pet portrait of your own pet. You can also reach us on Twitter, Instagram at TrueCrimeXS, or you can give us a call if you know anything about any of the cases that we're talking about at 252-365-5593. You can also reach us at Gmail at truecrimexs@gmail.com, and you can check out our website at www.truecrimexs.com. We'll see you next time.
This is True Crime XS.
Man, it's been a crazy summer. So I found myself engaged in this really big, sprawling, complex serial killer project. There's been a lot of follow-up on cases that we talked about earlier in the year. And then on top of that, involved in a documentary, and I've been involved in movie world. And, it's summertime as well. It's, I'm going to have a graduating senior, but that's a thing. It's sort of, it begins the first last of all the high school stuff. And, we added new dogs to our house this year. So it's been very, very busy. One of the things that came up that has probably taken precedent is how are we going to continue True Crime XS? We are there's going to be some stops and starts here and there because there's follow-up from another case that's going on in Texas right now. I've had some more trouble, believe it or not, with Texas giving me records. I had a sheriff's office just decide they're not going to respond to me at all. So I'm going through a whole process with that. We have several cases that take place in Texas that we're going to be dealing with as we sort of move into the fall. And then there's the Israel Keys stuff it's weird because now I'm on with 4 different jurisdictions where I'm starting to get little dribs and drabs of information. One of them, I'll just say I think I've identified to a very high probability the very first victim of Israel Keys. And that's going to be complex because it changes the whole picture of Israel Keys. And then we have another one where we think we found something that he was sort of talking about in the interviews. We think we found what happened there. Specifically, I do, and I'm trying to now talk Meg into going down that path with me. The thing about that one is he had this thing where he talked about it wasn't all going to be these little podunk police departments, and I always wondered what that meant. And this one involves 3 major police departments because there's this odd situation that happened where Keys' boat wasn't working anymore, and he leaves town, comes back to town, and then there's a really unique type of homicide that happens. And so it's one of those where the body is found, but it's not really publicized. Even to this day, there's not very much information. This is So it's possible that he just missed this one. I honestly think he missed it. I think that he thought the body was weighted down and it wasn't. But because of how it went down, it takes place in 3 jurisdictions. The missing person is in one jurisdiction. The body is found in another jurisdiction, but the body would have been put in the water at another jurisdiction. So that one's really complicated, but we started to look at it. And we found a missing couple that we can't explain, and that's very rare. We've had a couple where we're like, that's a car somewhere. But Meg and I dig deep into the couples cases. We always have because we're always curious about them. We have one that weirdly ties to February of 2012, although it's like just by location. It's not by time frame. It actually happens 9 years earlier. But we have a couple that we cannot explain what happened to them, and an area where people don't quite vanish like they do, and they're going to come up, and we're going to talk about them. And then I've got a project I'm obsessing over for the holiday times as well. So it's busy. It's a very busy year. There might be some gaps and some breaks in here, but we are working that out and working out how to incorporate it all. I have one particular serial killer project that won't make True Crime Excess any time soon that I'm pretty immersed in at the moment, and it's requiring a lot of my attention. But we're there, even if the feed seems a little light at times. We are recording and we are putting together quite a few interesting cases, trying to stick to things that people don't really talk about, with opinions that we feel like are unique perspectives on things.